The salt from this past day has been... Listen, a lot of you guys know that I play League of Legends, so I like to consider myself a little bit of a salt connoisseur, let's say, and this has been some quality salt. I'm gonna front. Delicious. So, last time we left our heroes, there was a filing for a hearing that was supposed to happen. There's a very angry puppy upstairs, by the way. He's mad. Puck's under the desk. He just had a bath. He's also mad because he just had a bath. There, so far as the mugshot has not been posted yet. As far as I know, he's not been picked up yet. But we'll get there. Last time we left our heroes, and Dragon Ball Z, or what I like to call Kyle Go Scree, we've got, we had the continued hearing, on the order to show cause, and to show why he's not in contempt. And surprise, surprise, he didn't show up. Shocking. So what we're going to be looking at now, we also saw that he was served by the sheriff's office at his new address that he did not update with the court as per the court's order. So where we're at now, I believe, is 64, because 63 is the service. So we're on 64. And essentially the 64 is a notice on Kyle, and this is a PDF of an email that was sent. And this was for the court, Mr. Curtis, the court requests that you promptly associate yourself with case number 2019 CVS 8163, McRae versus Curtis, on the court's electronic filing system to ensure you are notified of all filings. In order to associate yourself with a specific place, please first go to this link. After you enter your e-filing account information, user and password, and other credentials, click the Login button. On the screen that follows, search for your case by clicking Cases tab near the top, then click Cases in the drop-down list. In the box for case number, they gotta write this shit out in crayon because enter the case's number in the style format, 2019 CBS 1234 example. Then click the next box for county, and from the drop-down list, enter the county where the case originated. Next, select the e-file button. Listen, I'm nothing if not thorough. After a few seconds, you will be taken to the next screen. Click the box for document tape, and select Notice of Association from the drop-down list. Then click Next, which is near the bottom of the screen. On the next screen, click Submit. Once approved by the court, you will be associated to your case for the purposes of receiving very important notices of electronic filings, NEFs. I have also attached a document that contains more specific instructions on how to associate yourself with the case as a pro se litigant. Please let me know if you have any questions or require any assistance. Thank you. That's the court. This, it says this message, you forwarded this message, 05/12/2021. And then this says 05/12/2021. And then mechanism for case association. This is all instructions about how to file. I'm not going to go through everything, but it's just a step-by-step of what we just read, and it just includes screenshots of how to do exactly what they're doing. I'm going to go through this slowly so you can actually see that that's what it is. It's just the court demonstrating that we informed Kyle to do this and how to do this, so later on he can't say that he just didn't know how. Ooh, that puppy is mad. That's what Kyle's gonna sound like in jail. He's in like a little cage right now. It's the baby cage. And this is what Twitter's been doing since yesterday. So yes, this is all the e-filing. Your filing has been submitted. Blah, 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 blah. My filings. So this is all so he can't make the excuse that, oh, well, I didn't file with the court because I didn't know how. nonsense. So they're just nipping that in the bud so he can't make that argument later. Affidavit number 65. So this is what the court asked for from Steve at the end of the hearing where Kyle didn't show up. This would be Steve running at the speed of light as soon as he was informed that he needed to get this done. He basically started calling him Barry Allen for how quickly he went and got this notarized. So, North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163, affidavit of Stephen McCrae in support of contempt. I, Stephen McCrae, being duly sworn, state as follows. I am over the age of 18 and am competent to make this affidavit. As previously stated in my affidavit for show cause hearing, ECF number 58, defendant Kyle Curtis has not complied with the court's order granting partial judgment by default, ECF number 17, and to date I have received nothing from Mr. Curtis. The court held a show cause hearing on May 11th, 2021. That's the most recent hearing. That was not the most recent hearing. This was one of the first ones. May 11th, 2021. Mr. Curtis failed to appear at that hearing. The court held another show cause hearing on June 25th, 2021. Mr. Curtis again failed to appear. Neither myself nor my counsel have heard or had any communication with Mr. Curtis. Yeah. Given Mr. Curtis's behavior, I have reason to believe that he will not appear in this matter voluntarily, and therefore an order for his arrest should be entered. Dated, notarized, signed, blah, stamped, certificate of service. The undersigned hereby certifies that the copy of the foregoing was served via email and United States mail first class posted prepaid on the defendant to address as follows, which is the address that is submitted to the court right now. And then blah 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 law group. Neato. Order to show cause and notice of hearing. Order 66. I've been looking forward to Order 66. Inkboy for 2 said game over. It's game over, man. Game over. State of North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163, order to show cause and notice of hearing. This matter is before the court as a result of the court's order on amended motion to show cause entered on the 13th of May 2021, 13 May 2021, order ECF number 61, setting... That puppy is so mad. The baby rage. We get to listen to the baby rage of everybody throughout this entire stream. Is it a little bit blurry? I can zoom it in a little bit for you. We can make this a bit bigger. Why not? Let's do it. Let me zoom this in. There you go. There you go. Hopefully that's a little bit better. This matter is before the court as a result of the court's order on amended motion to show cause entered the 13th of May 2021, 13 May 2021, order ECF number 61, setting a hearing for 25th of June 2021, the second show cause hearing. This was the defendant Kyle Russell Curtis's, Mr. Curtis, second opportunity to show cause why he should not be held in civil contempt pursuant to Section 58-21 of the North Carolina General Statute for failure to comply with the court's partial judgment by default, the judgment, entered on the 23rd of January 2021, ECF number 17. Mr. Curtis failed to appear. Consequently, the court issues this order requiring Mr. Curtis to appear and show cause why he should not be held in criminal contempt pursuant to Section 5A-11 of North Carolina General Statutes for his failure to appear and to comply with the court's 13th May 2021 order. In addition, Mr. Curtis remains required to provide reasons why he should not be held in civil contempt for his continuing failure to comply with the judgment. Because the court finds probable cause to conclude that Mr. Curtis will not appear for a hearing as ordered, contemporaneously with this order, the court also issues an order for Mr. Curtis's arrest. Bum, bum, bum. Did I say 2021? This says 2021. Where did I say 2020? January 2020. 2021. I misread something. Feline's mad at me. Don't be mad at me. The court does not repeat, but incorporates by reference the procedural history in this matter and stated in the court's 19th of April 2021 order on amended motion to show cause, April 2021 order, paragraph 2 to 11, ECF number 57. Based on the pleadings of record and having considered all relevant matters, the court finds the following facts and makes the following conclusions of law. Finding of facts. Don't forget there are Traily Puffs in the chat if you're a member, so have fun with those. Finding of facts. The court entered partial judgment by default on January 23rd, 2020. The judgment required Mr. Curtis to do two things within 14 days. 1. Return administrative control and primary ownership rights of the Non Sequitur podcast YouTube channel and other accounts associated with the party's business endeavor to plaintiff. And 2. Provide plaintiff with all financial documents associated with Non Sequitur's financial affairs and financial condition. Mr. Curtis made an effort to comply with the judgment on the 4th of February 2020 by electronic filing with the court a series of documents he entitled, quote, Order Compliance and Financial Consideration, ECF number 18. To put that into perspective, we're currently on ECF number 66. But his effort was seriously lacking. I'm pretty sure that's what any woman has told Agrippa anytime that he's been around them. Seriously lacking your effort. Among other things, the reason I bring him up is because he's the one who did the financials. Among other things, Mr. Curtis did not produce valid usernames and passwords necessary to return control of the web-based accounts to plaintiff, and he did not provide all the required financial documents. This court alerted Mr. Curtis to these deficiencies by order dated 13th of April 2020, expressly warning him that the court's only means of compelling his compliance with the judgment was imprisonment for as long as the civil contempt continued. Order, motion, show cause, and motion set aside, paragraph 7, ECF number 26. Following a lengthy period allowing for circumstances resulting from the COVID-19 pandemic, on the 2nd of February 2021, this court issued an order requesting a status report from each of the parties, ECF number 53. Only plaintiff responded, alerting the court to Mr. Curtis's continuing failure to comply with the judgment, ECF number 54. Continuing failure does seem like a very, accurate description of this entire situation and everybody who's like a Kyle stan. And by Kyle stan, I mean Steve hater. Because that's pretty much all it is. Accordingly, on the 19th of April 2021, this court entered another order, this time finding that probable cause existed to determine that Mr. Curtis had willfully failed to comply with the court's judgment and setting a hearing for Mr. Curtis to appear and show cause why he should not be held in civil contempt. The 19th of April 2021 order. The parties were invited to file additional materials or testimony by affidavit prior to the hearing. The hearing date was set for the 11th of May 2021. Mr. Curtis, who is now pro se, note, registered as a party and created an account for filing materials with the court electronically. When doing so, he provided both his email address and his physical address. On 3 occasions, Mr. Curtis has filed materials electronically, evidencing his knowledge and ability to use the court's electronic filing system. See Order Compliance and Financials Consideration, Motion Set Aside, ECF number 19, Motion to Set Aside Default Judgment Revised, ECF number 20. And this is the little note for Mr. Curtis, who is now pro se. Note, Mr. Curtis was represented by counsel at various times earlier in this case. The court granted his most recent counsel's request to withdraw on the 20th of November 2020, ECF number 51. That's a very, very interesting note for a lot of reasons. I won't get into too much speculation now because I'm just trying to get through this. Maybe Steve will talk about this a little bit more after I'm done. Pursuant to North Carolina Business Court Rule BCR 3.8, Mr. Curtis was notified that the court would transmit all orders, decrees, judgments, and other matters through the court's electronic filing system, which in turn would generate a notice of filing to all counsel and, in this case, to him as a pro se defendant. Business Court Rule 3.8 makes clear that the issuance by the electronic filing system of a notice of filing for any order, decree, or judgment constitutes entry and service of the order, decree, or judgment. Neither Business Court Rule 3.8 nor the North Carolina Rule for Civil Procedure provide or contemplate that any other form of service is required. Mr. Curtis has not moved pursuant to Business Court Rule 3.2 to be relieved from his obligation to use the court's electronic filing system. While not required to do so, the court made efforts to have the Randolph County Sheriff's Department hand-deliver a copy of the court's 19th of April 2021 order to Mr. Curtis at his residence of record. An affidavit from the deputy who attempted service states that the deputy was unsuccessful in this effort and was informed by Mr. Curtis's mother, who was present at the address, that Mr. Curtis had moved to Riley, 4 months prior. See Randolph County Sheriff's Office Return of Service ECF number 60. Even if true that Mr. Curtis physically moved, a change of physical address does not affect one's email address, and it is Mr. Curtis's responsibility to provide accurate information and otherwise to comply with the rules of this court. This is savage. In response to the court's 19th of April 2021 order, plaintiff submitted an affidavit stating his position with the... Whoa. Hi, Puck. You all floofy? It's still a little bit damp? In response to the court's 19th of April 2021 order, plaintiff submitted an affidavit stating his position with respect to the rights and financial information he is due from Mr. Curtis, ECF number 58. Once again, Mr. Curtis did not respond in any respect. Raleigh. Oh, it's Raleigh. That's right. Raleigh. I don't care. Oh, give the dog boopos. The dog does need his boops. Can we get Puck in the chat? Boop. Yes. Who's your boop? Here he is. Boop. Yeah. At the hearing on the 11th of May 2021, plaintiff was present by counsel and was heard. Mr. Curtis did not appear. This court entered an order on the 13th of May 2021 in which it stated, quote, Were it not for the potential for COVID-19 concerns in this unprecedented time, Mr. Curtis's pro se status, Mr. Curtis's early, albeit insufficient attempt to respond to the judgment, and the gravity of the consequences for contempt, which include imprisonment, this court would issue an order to show cause requiring Mr. Curtis now to come forward and show cause as to why he should not be held in criminal contempt for his failure to abide by the court's orders to appear on the 11th of May 2021. However, under the circumstances, the court will schedule a second hearing to afford Mr. Curtis a final opportunity to either comply with the judgment or appear and show cause as to why he should not be held in civil contempt. End quote. The 13th of May 2021 order, paragraph 18. This is essentially the court saying, we gave you every opportunity to take responsibility for yourself and for this case and for what needed to be done. He didn't. In its 13th of May 2021 order, the court again warned that its, quote, only means of compelling compliance of a person found in civil contempt is imprisonment as long as the civil contempt continues. And as such, quote, Mr. Curtis should be prepared to be placed in the custody of the Sheriff of Guilford County should he not comply with the judgment and the court make an appropriate finding of civil contempt. End quote. The 13th of May 2021 order, paragraph 20. The court further warned, quote, the court is affording Mr. Curtis a third and final opportunity to comply with the judgment and, failing compliance, a second opportunity to show cause as to why the court should not find him in civil contempt. Should Mr. Curtis fail to make good use of this opportunity, the court is prepared to move forward with criminal contempt proceedings. End quote. The 13th of May 2021 order, paragraph 21, emphasis added. A hearing was set for the 25th of June 2021, note, to give Mr. Curtis a second opportunity to appear and show cause why he should not be held in civil contempt for failure to comply with the judgment. The note says the hearing to show cause was originally set for the 26th of May 2021, but it was reset to the 25th of June 2021 by order date 25th of May 2021 to ensure that the Wake County Sheriff's Department had located and served Mr. Curtis. To ensure Mr. Curtis had notice of the proceedings given their serious nature, on the 1st of June 2021, a Wake County Sheriff personally served Mr. Curtis at his place of residence with printed copies of 1. The judgment, 2. The 19th of April 2021 order, 3. The 13th of May 2021 order, 4. The order continuing hearing, ECF number 62, and 5. Instructions for associating pro se account with case on electronic filing system, ECF number 64, Wake County Sheriff's Office, Affidavit Service, Kyle Curtis, Affidavit Service, ECF number 63. Whew. Mr. Curtis did not appear at the hearing on the 25th of June 2021, and he did not respond with any of the required information and documentation specifically listed in the 13th of May 2021 order, paragraph 19. To date, Mr. Curtis has failed to comply with the judgment, and he has failed on 2 occasions to comply with the court's order to appear and show cause. Plaintiff has filed an affidavit recounting Mr. Curtis's history of failure to comply with the court's order in support of a probable cause finding pursuant to Section 5A-16B of the North Carolina General Statute, contempt affidavit. Conclusion of law. Here we go. The court concludes that Mr. Curtis has repeatedly violated its orders necessitating a show cause hearing to address two separate charges of contempt, a charge of civil contempt for failing to comply with the judgment, and a charge of criminal contempt for failing to appear and show cause in accordance with the court's 13th of May 2021 order. A civil contempt. North Carolina's civil contempt statute provides a failure to comply with an order of a court is a continuing civil contempt as long as the order remains in force, the purpose of the order may still be served by compliance with the order, the non-compliance by the person of whom the order is directed is willful, and the person whom the order is directed is able to comply with the order or is able to take reasonable measures that would enable the person to comply with the order. North Carolina General Statute, paragraph 5A-21A. The purpose of civil contempt is to, quote, prevent the rights of private parties and to compel obedience to orders and decrees made for the benefit of such parties. Till versus Berry, 234, North Carolina Apt 96, 102, 2014, citation omitted. Thank you for omitting the citation. Be blessed. The court may initiate civil contempt proceedings upon a finding of probable cause. See North Carolina General Statute, paragraph 5A-23A. See also Plasman v. Decca Furniture, USA, Inc., 2016, NCBC Lexus 20 at *6, North Carolina Superior Court, February 26, 2016. Quote, probable cause refers to those facts and circumstances within the judicial office's knowledge that and which he has reasonably trustworthy information which are sufficient to warrant a prudent man in believing that the alleged contemptor is in civil contempt. Young versus Mastrom Inc., 149, North Carolina Apt 483, 484 to 85, 2002, quoting State versus Williams, 314, North Carolina 337, 343, 1985. I am not having a happy Canada Day. I don't have any beer, and I wasn't able to go get anything. I thought we were canceling Canada Day. I seen that hashtag going around, and I because it's not canceled, I didn't get any beer, and I'm grumpy about it. I did get some pizza, though, and if you're on Twitter and you're in the know, you're in the know. Proceedings for civil contempt may be commenced, quote, by the order of a judicial official directing the alleged contemptor to appear at a specific reasonable time and show cause why he should not be held in civil contempt, end quote, North Carolina General Statute, paragraph 5A, 23A. Such an order may be issued on an affidavit of one with an interest in enforcing the order and a finding by a presiding judicial official that there is probable cause to believe the alleged contemptor should be held in contempt. IDC also Shoemaker versus Shoemaker, 137, North Carolina Apt 72, 76, 2000. Once it is determined that probable cause exists, the burden shifts to the alleged contemptor to show that he should not be held in contempt, that he lacks the means to comply, or that his non-compliance was not willful. Shoemaker 137, North Carolina App at 76, quotation, or citation, I should say. A court's only means of compelling compliance of a person found in civil contempt is imprisonment as long as the civil contempt continues subject to certain time limitations. See North Carolina General Statute, paragraph 5A-21B. An order holding a party in civil contempt must specify how the party may purge himself or herself of the contempt. North Carolina General Statute, paragraph 5A-23E. And imprisonment must end once the person has purged himself or herself of contempt. North Carolina General Statute, paragraph 5A-22A, quote within citation, because civil contempt seeks to coerce compliance rather than because civil contempt seeks to coerce rather than punish, the purge provision is essential to a civil contempt order, end quote. End citation of Red Valve Inc. versus Titan Valve Inc. 2019 NCBC Lexus 27 79 to 80, North Carolina Superior Court, September 3rd, 2019, quoting Ray Lackey Enters Inc. versus Ville in Lakeside Inc. 2016 NCBC Lexus 9 at asterisk 23, North Carolina Superior Court, January 29th, 2016. Based on the materials and affidavit testimony filed to date, the court finds that probable cause exists to find that Mr. Curtis willfully violated court's January 23, 2020 judgment, and specifically that he has failed to provide the information and documents ordered to be produced. The 13th of May 2021 order, paragraph 19. The court's 23rd of January 2020 judgment remains in effect. Likewise, the court's the 13th of May 2021 order specifying the documents and other information that Mr. Curtis is required to produce to satisfy the judgment remains in effect. The purpose of those orders may still be served by Mr. Curtis's compliance with them. Mr. Curtis's noncompliance appears to be willful. Quote, noncompliance with an order is willful when it involves either a positive action, a purposeful and deliberate act, in violation of a court order, or stubborn refusal to obey a court order, acting with knowledge and stubborn resistance. Plasman, 2016 NCBC Lexus 20 at asterisk 8, quoting Hancock versus Hancock, 122 North Carolina App 518 525 1996. Mr. Curtis's stubborn refusal to comply with the court's judgment is well documented in this case. See the 19th of April 2021 order, the 13th of May 2021 order. Moreover, Mr. Curtis has notice of and appears to be able to comply with the court's order. The Wake County Sheriff's Office served the orders on him personally. See Affidavit of Service. So, he is well aware of them. The documents and information at issue are either in his possession or available to him as evidenced by his prior submission. Order, compliance, and financial consideration. Basically what this means is that as soon as he filed his response like this, and then immediately went to, but I was never served, I didn't have that information, that's that getting completely thrown out. Not to mention that his motion to set aside the default was thrown out because him saying he wasn't served was nonsense. Nevertheless, he has neither complied nor made any attempt to comply with the court's judgment since the 3rd of February 2020, despite the court's warnings regarding the consequences of his non-compliance. Wait, when was this filed? Okay, hold on. I need to double check because this is February 3rd, 2020, and I thought. Hold on, we're going way back. We're jumping in the way back machine real quick. Where is his letter? Where's the letter? Motion to set aside. Okay, here we go. Order of compliance. This is the letter. This was the 4th. This is the 4th of February that this was submitted. So they're saying that including this letter, because this says the since February 3rd, they're saying as of the 4th, which was when this letter was submitted, that has neither complied nor made any attempt to comply since February, the 3rd of February 2021, which means his letter saying that he was going to comply or he was complying, they're saying that you have not complied nor made any attempt. They're basically tossing out his entire letter as like you did not comply or even try to comply with this letter. Wow. Whew. I mean, it kind of follows along with what Ben was saying. Mr. Curtis's failure to comply with the judgment and then failure to appear for not 1 but 2 show cause hearings as ordered by the court strongly suggests that he has acted willfully to disobey orders of this court. Nevertheless, the court will make no final findings of fact or conclusion of law with respect to ability or willfulness until it hears from Mr. Curtis, see Tichy versus Tichy, the 46 North Carolina App 332, 334, 1980, stating that to support a finding of willfulness in failing to comply, there must be evidence establishing as an affirmative fact that the party possessed the means to comply with the order at some time after the entry of the order. Reese v. Reese, 58 North Carolina App 404, 406 to 407, 1982. Quote, a defendant in civil contempt action will be fined or incarcerated only after a determination is made that the defendant was capable of complying with the court order. Citing Jolly v. Wright, 300 North Carolina, 83, 1980, McMiller v. McMillard, 77 North Carolina App 808, 809 to 10, 1985, vindicating an order for civil contempt because the record was unclear as to what evidence, if any, was taken to show the party's ability or lack of present ability to comply. Mr. Curtis is again directed to paragraph 19 of the court's 13th of May 2020 order for a list of the documents and information he is required to provide plaintiff, not the court, plaintiff. So Steve. B, criminal contempt. That was just A. Now we're on B, criminal contempt. Under North Carolina General Statute, paragraph 5A-11A3, a court may find a person in criminal contempt for the willful disobedience, resistance to, or interference with a court's lawful process. Oh, that's interesting. I wasn't aware of that. So if you're interfering with the court's lawful process, you may be held in criminal contempt. It doesn't say it has to be your case or you need to be a plaintiff in the case. Oh, I hear the wailing. Order, directive, or instruction, or its execution, end quote. Quote, willfulness in the criminal contempt statute means an act done deliberately and purposefully in violation of the law and without authority, justification, or excuse. State versus Fair, 193, North Carolina App 591, 594, 2008, quoting State versus Crisco? I don't know. 85, North Carolina App 155, 158, 1987. Our Court of Appeals has also stated that the willfulness element of criminal contempt, quote, involves more than deliberation or conscious choice. It also imports a bad faith disregard for authority and the law, end quote. Fort versus Fort. 65, North Carolina App 615, 616, 1983, citing Mowney versus Money. 268, North Carolina 254, 1966, West versus West 199, North Carolina 12, 1930. Criminal contempt. The pupper's mad again. Criminal contempt may be direct or indirect. North Carolina General Statute, paragraph 5A-13. Direct contempt is a behavior that takes place in the court's presence and may be punished summarily at the moment the contempt occurs. North Carolina General Statute, paragraph 5A-13, and two paragraphs. There's two of them. That's why there's double. Paragraph 5A-13 to paragraph 5A-14. Quote that's not a quote yet. I don't know, in Re-Nakel, 104, North Carolina App 638, 650 to 51, 1991, affirming trial court's holding of attorney in direct criminal contempt for repeatedly interrupting the judge, refusing to stop talking, failing to sit down, and encouraging his client to be disruptive. Quote, any criminal contempt other than direct criminal contempt is indirect criminal contempt and is punishable only by proceedings in accordance with the procedure for a plenary hearing requiring by North Carolina General Statute paragraph 5A-15, North Carolina General Statute 5A-13B. Failure to appear for a hearing as ordered is indirect criminal contempt. Cox v. Cox, 92, North Carolina, App 702, 707, 1989, determining that the party's failure to appear in response to a show cause order was indirect contempt because the court had no direct knowledge of facts to establish that the failure to appear was willful. Punishment for criminal contempt includes censure, imprisonment up to 30 days, fine not to exceed $500, or any combination of the three. North Carolina General Statute, paragraph 5A-12A. This is all the Steve haters losing their damn minds for that. That's what the sound this puppy is making right now. That's what it sounds. He is singing the songs of his people. The court will hold a plenary hearing on the 15th of July at 2021 at 10 a.m. in the courtroom 3D at the Guilford County Courthouse, 201 South Eugene Street, Greensboro, North Carolina, 27401. Mr. Curtis is ordered to appear and show cause why he should not be held in criminal contempt and sentenced in accordance with North Carolina General Statute, paragraph 5A-12A, for his failure to follow the court's 13th of May 2021 order. Mr. Curtis is aware of his right to counsel. Should he retain counsel, a notice of appearance should be filed at least 3 days prior to the 15th of July 2021 hearing. C. Order of arrest. Pursuant to North Carolina General Statute, paragraph 5A-16B, quote, if a judicial official who initiates plenary proceedings for contempt under North Carolina General Statute, paragraph 5A-15, finds, based on sworn statement or affidavit, probable cause to believe the person ordered to appear will not appear in response to the order, she or he may issue an order for arrest of the person pursuant to North Carolina General Statute, paragraph 15A-305. Mr. McCrae submitted an affidavit to this court contending that probable cause exists to find that Mr. Curtis will not appear voluntarily at the contempt proceedings against him given Mr. Curtis's prior behavior. Contempt affidavit. In support of that contention, Mr. McCrae provides that Mr. Curtis has not complied with the court's judgment entered 18 months ago in this case. Contempt affidavit, paragraph 2. Mr. Curtis failed to appear at the first show cause hearing on the 11th of May 2021, contempt affidavit, paragraph 3. Mr. Curtis failed to appear at the second show cause hearing held on the 25th of June 2021, contempt affidavit, paragraph 4. And Mr. Curtis has not communicated in any way with Mr. McCrae or Mr. McCrae's counsel, contempt affidavit, paragraph 5. Oh, Puck, did you get spooked? Okay, yeah, you go under there. Firework went off. Puck does not like fireworks. The court finds probable cause to believe that Mr. Curtis will not appear for the contempt proceedings against him scheduled for the 15th of July 2021. A separate order for arrest will issue. Conclusion. It is hereby ordered that defendant Kyle Russell Curtis shall appear before the court at 10 a.m. on Thursday, the 15th of July, 2021, in courtroom 3D of Guilford County Courthouse, 201 South Eugene Street, Greensboro, North Carolina, 27401, to show cause why he should not be found in criminal contempt for failing to comply with the court's 13th of May 2021 order. It is further ordered that defendant Kyle Russell Curtis shall appear before the court at 10 a.m. on Thursday, the 15th of July, 2021, in courtroom 3D of the Guilford County Courthouse, 201 South Eugene Street, Greensboro, North Carolina, 2741, to show cause why he should not be found in civil contempt for failing to comply with the judgment in this matter. It is further ordered that Mr. Curtis immediately update his address on the court's electronic filing system to reflect his current residence, and that he follow the directions the court has provided to associate himself with the case in the court's electronic system. Should Mr. Curtis change his address in the future, he is ordered to update that change on his user profile in the court's electronic filing system within 24 hours of his change of address. Should Mr. Curtis decide to retain counsel, he should do so promptly and shall have such counsel file a notice of appearance at least 3 days in advance of the 15th of July 2021 hearing. Nothing in this court's order prevents the parties from engaging in discovery in accordance with the business court rules and North Carolina rules of civil procedure. It is ordered this the 30th day of June 2021. Juliana, the new judge, dropping that hammer. Holy damn. Hi, Puck. What are you doing? You need to pick a lane, buddy. You gonna go hide in the bathroom? You just had a bath in there. Are you sure that's where you want to go? 14 pages. 14 pages. Ugh. We're not done. That was Order 66. This was an appropriate Order 66. I'm glad this was the 66th order. Like, 66th docket. This was the court, by the way. This isn't Steve arguing. This isn't Steve's lawyer arguing. This isn't any argument going on. This is the court stating and accepts as fact. So, you got an issue with it? You want to take up some problems? Take it up with the court. So, Order 67. Order of arrest. State of North Carolina. The state of North Carolina versus Kyle Russer Curtis. New address for Kyle, where he was served. This is the address we show, that was on the, what is it? The affidavit service from the sheriff. Side note, saying isn't going to be his address for much longer. His address is going to be jail. Probably prison. Race, sex, doesn't have a lot of this other information, which is fine, isn't needed. Guilford County, Superior Court Division, marked off as probable cause that defendant may fail to appear, criminal contempt, and then General Statute 15A-305B9. I'll zoom this in a little bit for you guys so you can see it a little better. 5A16, this court has initiated plenary processing proceedings for contempt against the defendant under General Statute 5A16, has issued a show cause order and find probable cause to believe that defendant will not appear as required in response to that order. You are directed to take the defendant into custody and bring the defendant before judicial official for the purpose of determining conditions of release and for commitment if the defendant is unable to comply. Signature, Guilford County Courthouse, dated. That's the date of the hearing. That's the court time. Oh, that's date issued 25th, and date of offense the 25th, date issued the 30th. There's the bond amount, right? Defendant failed to appear. Amount for the bond is 10 grand. And then there's the return service thing, which nothing's clicked off on this, so. But that's it. That's where we end our saga for now, until the 15th. Where Kyle until we get a mugshot. It might be fun to compare his old mugshot with his new mugshot. How it's going, how it was going, how it's going now, and they're both just mugshots. We'll see how it goes. We've got Kyle showing up in an orange jumpsuit in chains on the 15th. As drugged there by the sheriff's office arresting him. spicy. So, if anybody has any questions, we are doing a Q&A episode of Judgment Call on Monday. If you would like, Steve is going live to kind of talk about this a little bit more over on his channel as soon as we're done here, so feel free to go and head over there. Have fun, enjoy. I'll probably be over there. I don't know if I'm going to be in the call that they're doing if they do a call, but I'll be in the live chat. I'll be around. But yeah, I can see the headlines now. YouTuber goes to jail over stolen YouTube channel and $60,000. Gets tased. I hope you guys... Can you claim the bounty? Go for it. If you think you can. I can't tell you no. That's a you decision. If anybody has been enjoying the absolute shit show that Twitter has been... Kyle's stans and Kyle's supporters, who aren't really actually Kyle supporters, they're mostly just we hate Steve supporters, have been losing their they sound like that puppy. I assure you. Go check out Twitter and watch the watch that fun break. It's like a collective. You know how somebody has like a mental breakdown on Twitter and they flip out? It's like that, but it's like if it was the Borg, because they're all doing it all at once, and it's just like an implosion. Although, I do enjoy, or at least I would like to check out, what appears to me, and maybe to converse and talk about more with a couple people, but it appears to me that in Order 66, a certain internet lawyer, definitely not Kyle's lawyer, appears to be mentioned twice, although not by name, but something to potentially discuss another time, as I'm not looking here to speculate too much. I'm mostly here to just provide this to you. Once the hearing goes through and we get a little bit more information about what's going on, I will update you further when we get more filings. I'll see you next time. I will be live tomorrow with my very first, what is probably going to end up sadly being a series called Dumb Feck Friday. So if you would like to check that out, I definitely recommend it. It's going to be fun. It's mostly for the giggles. It's mostly just a goof, but also to, you know, be poignant at the same time. Normally, my normal shtick. Like and subscribe, become a member if you would like to support the channel. I did see our NGD Gaming become a member. Thank you very much. It's greatly appreciated. Super chats allow Puck to get more boops. Feel free to boop the subscribe button and the notification bell. If you do become a member or a Patreon, there's a bunch of additional stuff over on the Discord, and I definitely welcome you to come and join our conversations there, where we will probably be talking about this a little bit more and laughing at the Twitter explosion. Anyway, I will catch you guys next time. I will see you soon. This has been fun. Arrest warrant! Oh yeah, Kyle's never gonna go to jail. Oh, Kyle will never get arrested. No, it's never gonna happen. There's nothing like enjoying the death throes of sore losers who lost in September of 2019. I'll catch you guys next time. I'll see you over at Steve's channel. He said he was going to stream at about 5 PST, which would be 8 Eastern, so that's in about a half an hour. So I'll see you guys soon. Bye-bye.